Oh, good. Sorry, my throat is not working so great today.
It's okay, as long as you talk like that.
All right, so you guys can interrupt. Let me just get a sense before I start. How many of you have studied the legal system in any way, shape, or form before today? Like, raise your hand. Like, half of you, some of you. Like, so, do you guys? How many would you say you know more about the legal system through television or through actually studying about it? Who would say television? Raise your hand. All right. How about studying? How about through a parent? Anybody who has a parent in the legal system? Like what? What does your parent do?
Well, my mother's paralegal, and I've met Rick Gonzalez, who actually did a famous case in Florida.
Okay.
Gays' rights against being able to adopt.
Right.
And Rick Gonzalez, and I know Benjamin.
Okay. Anybody else have a?
Clark.
Okay, got it. Anybody else have a parent? No. No. No other parents, relatives, brothers, sisters, cousins, nephews. Okay. All right. Well, I'm going to talk briefly about proof in the legal system, and it's really not like you see on television. And I'm going to tell you a little bit about it. As you may or may not know, we have two systems of justice in our country, right? One is federal, which applies. So my position was federal. I was the U.S. attorney in charge of the Southern District of Florida. So I was in federal court. We were handling civil and criminal cases on behalf of the U.S. So most of our lawyers were prosecutors in criminal cases, but some of them were civil lawyers who were handling civil cases for the government, either for defending the government or on behalf of the government. Then we have a state system. So how many people have gotten a traffic ticket, gone to state court? Yeah. So how many people here have been to federal court? Raise your hand. Do you even know where the federal courthouse is in Miami? It's downtown. Do you know where Dade downtown is? Like that right there on 5th Street, not far from the arena where the Heat play. So right across the Dade downtown campus, there's a bunch of buildings, and there's 3 or 4 different courthouses there, and that's where all the federal judges work and the federal magistrate judges work and prosecutors and defense attorneys work. So I actually have a little PowerPoint that I put together with Audrey's help, see if this works. How many have seen that? How many people have seen that before? So if you go to the state courthouse, that sign is in, and actually, I'm not sure. It used to be in the federal courthouse, but it's not there anymore in the federal courtrooms. But this is the slogan that you see that a lot of judges have in their courtrooms in the state courthouse. And supposedly, what the legal system is there to do, and what the rules of proof, which we call rules of evidence, are there to do, is to find out what the truth is. And what you learn when you've been a lawyer for a long time is that it's not necessarily easy to find out what the truth is, because when you have a dispute in court, two people come in and they have competing versions of what they think is the truth. And a lot of people make fun of this sign. Some people don't think it's really true, that people who go to court really go there to hide the truth, not to discover the truth. But that is what the state courthouse picture says. And the U.S. Constitution, which I highly recommend you guys should all read, it's not that big. It's like, I got a little pamphlet right here. In the preamble says, we the people, by the way, you should go to this place in Philadelphia. If you're ever there, it's called the Constitution Center. And it's a great place where you can learn about the Constitution of the United States, and it's a really phenomenal place. So if you ever get a chance to go to Philadelphia, do not go to Philadelphia without going to the Constitution Center. You see that this was the preamble. This is what the purpose of the Constitution is. And one of the things that the Constitution is meant to establish is called justice. Now, you guys know what the Bill of Rights is, right? Bill of Rights, First Amendment, Second Amendment, Third Amendment, Fourth Amendment, Fifth Amendment. Read those and you'll see that, I mean, I read them. I've been practicing law now for almost 30 years. So how many more times is that than you? More than 7 times. That's pretty scary. When you read those, you'll see that the first 10 amendments have a lot to say about justice and about our rights against the government when we're prosecuted, for example, for a crime. And also, the Constitution itself talks about the federal court system and how it's established. So the way the court system works is today in the modern era, we have these big rule books. See this? It's crazy. Now, this is not just the rules of evidence, which this slide talks about. These are the rules of civil procedure, appellate procedure. There are rules in here dealing with the Supreme Court of the United States. There are some certain statutes that deal with procedure and evidence in court. So this book is just a summary, really. Well, it's more than a summary, but it's a compilation of the federal civil judicial criminal rules. Now, there's another book just this thick for criminal cases. So since I work in both civil and criminal cases, in both federal and state court, I have, or should have, 4 sets of these behind my desk. One for federal civil cases, one for federal criminal cases, one for state civil cases, and one for state criminal cases. If I got them all correctly. Yes?
Would the state one be unique to state you're in if you're practicing anywhere else?
Yeah, like here in Florida, we have the Florida, for example, if I pull out the book that deals with Florida, it's the Florida Rules of Civil Procedure. Now, I don't want to get too technical about that, but they're similar to the federal rules, but they're different in some ways. So if I'm practicing law, sometimes I have an issue in a case, and I have a rule that applies in the state case. There might be a different rule in the federal case, so it can sometimes affect how you proceed in the case. What are rules there? But I just want to focus on the rules of evidence. And if you look at this book, 116 pages of this, which is pretty thick, this much of it, single-spaced, are the rules of evidence. And you guys have heard of some of the rules of evidence, right? Like hearsay. Right.
Like
Do you know anybody know what hearsay is? Yes.
Lying in court.
Lying in court. Wrong. Next.
hearsay is not evidence based upon, like secondary evidence is based on, I've heard somebody say this.
It's close. Closer. Yes.
It's not backed by real evidence.
Not. Hearsay. So what is hearsay? Hearsay is someone who comes into court and says that someone else said something. Okay? So that someone else we call the declarant. So instead of me coming in and saying, I saw Audrey shoot what do they call you? Sorry.
They call me JC.
JC. Sorry, I didn't know whether to call you Dean or what.
They call me JC. They call me Kudo.
Like if I'm a witness, right, and I come in and I say I saw Audrey shoot JC, then that's not hearsay because I actually saw it, direct evidence, right? But if I come into court and I say, what's your name? Say it again. Shinez. Okay. If I come into court and I say Shinez told me that Audrey shot JC, that's hearsay. Okay, got it? Okay.
Can you subpoena the person that you're saying said something?
Yeah, you can subpoena somebody if you find them, but sometimes you can't find them. Like sometimes the person's dead. What if I say before she died? Sorry. Right before she died, Shinez told me that Audrey shot JC. Okay? Now, that actually is hearsay. But there are exceptions to the hearsay rule. that allow that to come into court. And that exception is called a dying declaration, and there's rules. And actually, you go to this rule book, and you'll find a whole list of hearsay exceptions. There's like 25 of them. And each of those hearsay exceptions is it's not controversial, but it's litigated. People argue about it. There are certain times, in certain circumstances, why a dying declaration would be allowed in or not. So anyways, I'm getting ahead of myself. So that's the federal rules of evidence. And the rules go back to the Middle Ages in England. We started having, the first time anybody ever wrote this that we can tell, and the first time in English, our system is built on the common law of England, right? So we revolted against the British, but we kept their legal systems. And it was called the common law system. So back in England, there was a guy named Gilbert who wrote a treatise in 1754, and he was the guy that wrote the first book of evidence. And that evidence actually had been developing over the years since the Middle Ages in courts. And back then, a lot of evidence had to do with written documents like deeds and wills and contracts. And back then in England, if you were a party in a civil case, so like if I'm suing, what's your name?
Charles.
If I'm suing Charles for breach of contract because he owes me $100 that he promised to pay me if I mowed his lawn, if we were back in England back then, and we were in a civil court over that civil dispute, neither Charles nor me could testify because parties were disqualified. They were presumed to be too interested in the matter and therefore likely to lie about it, so they weren't allowed to testify, but witnesses could testify. So what's your name? Patricia. So Patricia could say, I saw Charles mowing my yard, and then that would be good for Charles. So, or me mowing Charles's yard, that would be good for me. So that's back in the old days, and now we're in the modern days, right? So I hope this gets printed out if you guys want. You can pass it around, whatever. This is a little complicated, but how many people here think jury trials are a good thing? And how many people here think jury trials are a bad thing? Like, raise your hand if you think it's a good thing. Okay? Like higher so I can see you. Okay. All right, raise your hand if you think it's a bad thing. Who thinks jury trials are bad? Okay. Well, back in England, they had jury trials for civil cases, and they had jury trials for criminal cases. But it was very different than the jury trial we see today on television. For example, the rules of evidence were different, but also back then in England, the judge was a lot more involved with the jury and actually judges, I read this great book about the history of evidence. Back in England, we have a record of a judge who was there for 2 years, took shorthand, wrote really careful notes, so we studied what he did. And actually, when juries came back and came back with a verdict that the judge didn't like, sometimes he would say to the jury, you know what, you should consider this, this, and that, and go back and redeliberate and try again. So they were active, they were really involved in the jury's decision on what the facts were, because under our legal system, juries determine facts, right? Because trials are about determining what is a fact, what actually happened in the past. So in our system today, juries do that without the judge being so involved. Now judges give juries instructions about what the law is, but they're not supposed to get involved in what the jury decides in terms of what the facts are. That's up to the jury to decide. So the judge decides the law and instructs the jury on the law, but it's the jury only itself decides what the facts are. Okay? Does that make sense? Everybody follow me so far? So the reason why this law of evidence has developed so much in our country and why these books are so thick is because juries today have to be protected in some ways from themselves. Like if you're on a jury, you're supposed to only listen to what's presented to you in court. You shouldn't go and read the newspaper about what's going on. You shouldn't go on Facebook and try to find whether or not the plaintiff or the defendant has a Facebook account. You're supposed to go home every day and just go like this and only think about what happened in court, because you can't look at anything else that happened outside of court. So these rules do the same thing. They basically say they protect the jury from relying on evidence or relying on things that aren't evidence and that they shouldn't consider in reaching their decision. That makes sense? Any questions so far? So today, the rules have a prophylactic purpose. Prophylactic, preventive. They prevent juries from the shortcomings of our jury trial system, and that shortcomings is too strong of a word, but they prevent the jury from hearing evidence that might mislead them, okay? And we talked about hearsay. Back in the days of England, when I was telling you about that judge in 1754, hearsay was really technically not allowed, but since the judges were so involved in the decision, they would let hearsay in sometimes, and they would think, okay, well, I'll decide how much weight or how much credit I give to that hearsay statement. Today, the rule is the opposite. It goes to whether or not the evidence is admissible in court, whether it comes in the first place, and it's not something that we let juries decide how much weight to give to hearsay, because we have very strict rules on what kinds of hearsay they can consider and what kinds of hearsay they can't consider. So I talked a little bit about the rules of evidence and how our system of justice works, and now we're going to talk about what someone has to do in court to prove the proposition that they're advancing, right? Because proof means, what is proof? Proof is what?
Evidence.
Proof is evidence, something that supports a proposition that you're trying to advance, right? And in our system of justice, also going back to the days of Rome and back to the philosophical days way before Rome, basically, if you in a debate, you're the one. If you want to advance a proposition or try to prove a fact, it's your burden. You're the one that has the burden, the responsibility to prove it. The person who is on the other side of the debate can just deny it, because you can't prove a negative. You can't prove that something doesn't exist. Well, sometimes you can, but you know what I mean. It's up to the person. So we have different, in our system, we have different burdens. In the civil system and in the criminal system, we have different burdens. In the civil system, you have what's called preponderance of the evidence. And preponderance of the evidence is actually a pattern jury instruction. So it's not in this book, but if you went to the state book, I'm sorry, it is in this book. This is federal court. Ignore this. That says federal. So in our federal courts here in Florida, if you're in a civil case, this is the instruction that the jury gets, or one of the instructions that the jury gets on what the preponderance of the evidence is. And as you can see, it's a balancing scale. So a lot of times you'll see a lawyer, and I don't know if they do this on TV or not, because I used to watch LA Law a long time ago, which really dates me, but I don't really watch those shows. I think CSI is pretty good, and Law and Order is pretty good, but most of those shows are crazy. But you might see a lawyer on TV doing a closing argument and talking about which evidence favors which side. And in a civil case, it's just really, you just have to have a little bit more than the other side. You have to tip the scale. So some lawyers will say, well, even if 51% of the evidence supports our side, you have to rule in our favor. And that's really what the law is. More of the evidence has to favor one side, just a little bit more, like a scale. All right, so that's civil. In criminal, who's heard of this? Beyond a reasonable doubt. Okay. Is that in the Constitution or in the Bill of Rights? Who thinks that it's in the Constitution or the Bill of Rights? Raise your hand. No. You think it is?
Yeah.
Who thinks it is in the Constitution or the Bill of Rights? Raise your hand. A couple people? Okay. It's actually not in the Constitution. The Constitution talks about, the Bill of Rights talks about several things in criminal cases that you guys have heard of. A lot of them are in the Fifth Amendment, which is, and I'll get to the really famous parts of the Fifth Amendment. No person shall be subject to the same offense, for the same offense, to be twice put in jeopardy, double jeopardy. That means you can't be tried twice for the same crime, right? If the prosecutor tries you and loses the case, that's it. You're free. They can't try you again.
That apply in all state courts?
That applies all. This applies everywhere. It applies in federal courts, state courts. The federal law is the law of the land, supreme law of the land. So the state courts have to follow the U.S. Constitution and the U.S. Bill of Rights. Nor shall any person be deprived of life, liberty, or property without due process of law. Heard about that? Amendment number 6 says you have the right to a speedy trial. It's a big right. They can't put you in prison for 2 years and then try you later. You have to have a speedy trial. You have the right to a trial by an impartial jury, okay, a disinterested jury. You have to be informed of the nature of your crime. You have to be confronted with the witnesses against you. You have to have compulsive process. Somebody talked about subpoena. You have a constitutional right to subpoena people to go in your trial. And you cannot be compelled to testify against yourself, right? That's the most important one that a lot of people remember. Take the 5th. I take the 5th, all right? So, but reasonable doubt has been in the law for a long time. It was in the law back in England in the late 18th century, like in the 1780s, 1790s. You started seeing judges apply the reasonable doubt standard. They called it something else, but it was very much like our reasonable doubt standard. And then in the U.S., a lot of the states started adopting it. And you can read this, but the key part here is there is a real possibility that the defendant is not guilty. And then there's the presumption of innocence. That's Black's Law Dictionary. This is a judge in Massachusetts in 1850. Massachusetts adopted the reasonable doubt standard very early. And this is a really long thing you can read too, but I highlighted the part that's important. It's not a mere possible doubt. It's got to be an abiding conviction to a moral certainty of the truth of the charge. That's what reasonable doubt is. It's not any doubt. It's reasonable doubt. And then federal. Remember we talked about federal? The federal instruction that's given to every jury that tries or hears the trial of a criminal case in Florida, this is what the judge tells the jury that a reasonable doubt is. The government's burden is heavy, but it doesn't have to prove a defendant's guilt beyond all possible doubt. So it's not all possible doubt. The government's proof only has to exclude any reasonable doubt, and it's a real doubt, this is my favorite part, based on reason and common sense. So it's got to be a doubt based on reason and common sense, not on just whatever you want to feel like it is. And it has to be something that it's got to be a doubt so strong, the proof has to be so convincing that you would be willing to rely on it without hesitation in the most important of your own affairs. You know what's so great about this instruction? This instruction is good for both the prosecutor, the government, and the defendant, and the defense attorney, because there are parts of this that support whatever you want to argue about reasonable doubt. So when I was a prosecutor, I was a U.S. attorney from 2002 to 2005. So I was the head of the office, and I had 230 prosecutors under me. So I didn't really go to court very much, because that's more like a CEO role where you have to make sure you handle everything, and you have to deal with all the problems and the fights and the press and all that. It's great. It's a really awesome job. But earlier in my career, when I was Audrey's year out of school, like about a fourth-year lawyer. I left my firm, so I left. It's like today, Audrey leaving McDermott, Will and Emery, and I became an assistant U.S. attorney. So I was an assistant prosecutor. I was a line attorney. I was actually in court trying cases. And whenever I did a closing argument to the jury and we talked about reasonable doubt, I would stress this: use your common sense, use your reason. It's not any doubt. It's a reason that makes sense. And then I would turn to the defendant and say, here's all the stuff they're saying. I would say a little bit better than that. But here's all their stuff they're saying, and this is why it doesn't make any sense. Or this is how they're attacking my case, and it doesn't make sense. So my whole thing was always talking about what made sense or not. And that resonated, right? That's something that really resonated with the jury. Now the defense attorneys would get up and they would talk about this. You have to be so convinced of the government's proof that you would, without hesitation, in the most of your important affairs, rely on that proof. And they would go to town on that. So it's actually a great instruction, and it talks a lot about reasonable doubt. So the difference between civil, it's not preponderance of the evidence, it's not balancing the scales. Reasonable doubt, some defense attorneys would say is like this. You have to have that much evidence on the prosecution side to convict. So those are the different standards of proof. Now, who knows who this guy is? Okay. All right. How many people here? George Zimmerman was charged with second-degree murder, which requires willful intent and spite and ill will. And then in the middle of the trial, they also asked that the jury be allowed to find them guilty of a lesser charge called manslaughter. But how many people think that George Zimmerman was guilty? Raise your hand. Okay. How many people think he was not guilty? Okay. It's pretty even.
I actually have a question about that one.
Yeah.
He used the gun in his fight, correct? He killed Trayvon Martin with the gun, correct?
Yes.
Now, I might have this wrong because someone told me, so I'm not entirely sure.
Hearsay.
But in Florida law, if you injure the person with the gun but you do not kill them, and they sue you for that, can they win?
Yeah, it depends. I mean, if I...
So if Trayvon Martin had gotten injured by the guy and then sued Zimmerman for injuring him, Zimmerman would
It would have been a much different case because it wouldn't just be George Zimmerman talking about what happened. It would have been Trayvon Martin talking about what happened. So it would have been a different criminal case and it would have been a different civil case. So here's what the New York Times, which is the best newspaper in the country, seriously, even though I'm a Republican, I'll tell you that. I read it every weekend. You should too. The New York Times is great. Here's what the New York Times said after the Zimmerman verdict. It said, the fight between Mr. Martin and Mr. Zimmerman that preceded the shooting produced a muddle of testimony and grist for reasonable doubt. So what happened in Zimmerman is that there was a fight. Zimmerman got hurt. You can see from the photos, he clearly was hurt. I mean, the guy's nose is broken and all that. And I could talk to you about, even though I didn't follow it that closely, I've read about it. I could talk to you about the Zimmerman case for an hour because it really shows how difficult sometimes it can be to determine what facts are and how difficult it is to prove something. Because the prosecution had to prove that Zimmerman had spite and ill will and actually shot Trayvon Martin and killed him for that reason. The defense wanted to prove that Zimmerman was acting in self-defense, and therefore he was not guilty of having spite and ill will. And what happened in the trial is Zimmerman didn't testify because, I just read it, he has a right not to testify. He has a right not to incriminate himself. But he was interviewed a lot on camera by the detectives and by the investigators after the death of Trayvon Martin and before the trial. So they played, he basically was able to tell his story through his incident, you know, it's post-incident stuff. So what Zimmerman said, without testifying, because he was on, you know, I think they recorded a lot of what his statements were, is that he got out of the car. Trayvon Martin apparently, you know, couldn't find him. Martin like went away, and he got out of the car not to chase Trayvon Martin and not to follow him, which the people who think he's guilty think he did. He just, you know, because he was told, don't get out of the car. The dispatcher said, stay in your car. But he got out of the car, he says, to look at the street sign and make sure he knew where he was at, and because he couldn't see the guy, and so that he could direct the police on where to go. And then he says that when he was walking back to his van, he got attacked. He got jumped by Trayvon Martin, who started beating his head against the sidewalk. And then, Zimmerman had a gun, and then they struggled over the gun, and then he shot Trayvon in self-defense. All right? So the problem is no one saw what happened. There was no first-hand evidence. The only person who saw what happened who's still alive is George Zimmerman. So he testified, kind of, through these post-incident statements, and he told his story. And then you had neighbors testify about stuff they heard, and then there's a call where there's a call, I don't know if you guys follow the trial, but there's a call where somebody's yelling for help, and you had some witnesses go to court and say, oh, that's Zimmerman's voice, and other witnesses go to court and say, that's Trayvon Martin's voice. So, unfortunately for Trayvon Martin and his parents, the only proof that the state was able to produce was a muddle. It was very confused. There were people saying, some people were saying one thing, some people were saying others. I could talk to you a lot more about the scientific evidence in the case, which didn't help the state either, and the investigators who didn't help the state either. But that was reasonable doubt, okay? Yes?
Question, controversial question. Honestly, if this had been white on white or black on black, would have been a completely less of a big deal.
Probably. I don't know. I mean, Zimmerman said, by the way, that he did not get out of the car because Trayvon was black. He did not, or African American. He did not get out of the. He's not prejudiced because he himself is a minority. He's a Hispanic, even though his name is Zimmerman, and so that really wasn't. That may be true. You got anybody else had a question about Zimmerman back there?
Yes. Could the prosecution have made a case in order to make that those videos inadmissible in court? Because I followed it on TV, but we discussed it, but I didn't quite understand.
Which statements?
The videos of Zimmerman.
Oh, Zimmerman?
Interview.
Yeah.
Because it did give the defense the upper hand. The prosecution wasn't able to.
Yeah, the prosecution actually, in this gets into the rules of evidence, but the hearsay rules allow one side to put into evidence whatever the other side says. That's not hearsay. Okay, so in the example of the Audrey shooting JC case, right? And Shanez says, I think you're the one that told me that Audrey shot JC, right? Okay, if we were suing each other because if you were suing me because you're JC's sister, and you're trying to prove that I'm the one that actually shot JC, not Audrey, and you told me, oh, Audrey shot JC. I as a defendant, because you're suing me, I could bring in your prior statement, which is inconsistent with what you're saying now. I'm innocent because the person suing me said it was someone else who shot JC, not me. So that's a hearsay exception. So in your example, the state could bring in whatever Zimmerman said because he was the defendant. That's a statement by a party opponent. Zimmerman couldn't do it necessarily unless he was doing it to corroborate something else. And I didn't follow the trial that closely to know who introduced it, but I bet you the state introduced a lot of it. Okay. Did you have a question on Zimmerman?
Do you think he would have had a better case if they just charged manslaughter originally off the prosecution?
Maybe. Yeah.
I think part of the mistake was they tried for a second degree, right? With grab
Yeah.
that. Yeah.
Yeah, that's possible. That's possible. So, and I think this is, we're almost at the end. In criminal cases, we talked about reasonable doubt, right? There's also other burdens that apply in criminal cases. So, for the police to stop you, they have to have reasonable suspicion. That's a very loosey-goosey standard. For you to be arrested or searched or indicted, indictment happens before you go to trial. There has to be probable cause, and that means sufficient reason to believe a crime has been committed. And these are the things, these are the burdens that apply in criminal cases before you get to trial. When you get to trial is when you have to prove beyond a reasonable doubt. So it's easy to charge somebody. It's easier to charge somebody because you just have to prove probable cause. But to convict them, you have to prove beyond a reasonable doubt. Okay? So I didn't really talk a lot about inductive versus deductive and those kinds of reasonings and those kinds of philosophical things because I really wanted to talk about more about how facts are proven in court, right? How proof works in court. Hopefully this gave you a little bit of an example or a little bit of an education about that. All right? Any questions?
No.
Yes?
Yeah, just because something is a law, like after college.
Yes. Yeah, there is civil disobedience, and that actually has worked, like in the civil rights days. Yes.
Is there any significant discretion between Florida civil law and federal civil law? Like any major differences?
You'd have to be more specific, like in what, in terms of evidence or what?
Anything. If you think of any.
Oh, well, some cases you cannot bring in federal court. Federal court, for you to bring a civil case in federal court, it's a court of limited jurisdiction. So, for example, you don't see regular murders and regular street crimes, regular contract disputes. You don't see those things in federal court because it has to be disputes between citizens of different states. It has to be a dispute involving the federal government. It has to be a dispute involving a federal statute. It has to be a dispute involving the Constitution. Like if I believe the government violated my constitutional rights, I can bring an action in court. And so state courts have a lot broader jurisdiction to hear more disputes, and that's why you have traffic tickets in state court. You have wills in state court. You have more regular civil cases in state court. Federal courts are more limited. It's the only word I can use. Yes?
What do you think the role of technology or the influence technology has had or will have on law and how it's evolving?
Huge. For one thing, what I didn't, we could go into detail. The rules of evidence talk about relevance, privileges, witnesses, experts, like people bring in expert testimony, when you can bring an expert or not. And then that's the rules of evidence. But the rules of procedure give you the right to take what's called discovery. You can take depositions, you can ask the other side to produce documents. And in some of the disputes that we work in, where corporations are suing each other, in a civil case where IBM is suing Xerox or Google is suing Facebook, sometimes a production request, a request for documents by the other side can involve many gigabytes of data. So now we have special electronic discovery rules, how you discover information that's in a computer versus printed on a piece of paper. So that's had a big impact. Technology has also impacted a lot, like I said before, about how you pick jurors. Like if I go to trial and I can figure out the name of the jurors in advance, if I can do some, and you can only do that in very specific cases. But if you can discover the names of the jurors in advance, you would want to do as much investigation as you would about them. And if they have an open Facebook account, you want to look at the Facebook to see whether they favor certain things or other things. So technology is revolutionizing the world. It has an effect on me. because when I started practicing law, we actually didn't have these things. We still used fax machines, and fax machines, you don't really, I mean, people still have fax machines, but you don't really use them anymore. But you didn't send documents through email. You sent letters to the other side as opposed to emails to the other side. And nobody could, I couldn't check my email at 10 o'clock at night, which is great. But now, clients expect you, if they want to talk to you, they'll send you an email at 10 o'clock at night or 1 o'clock in the morning. And some of them expect you to read it, be available. So technology is great, but it also enslaves lawyers also. And professors. Yes.
So you mentioned that in this book and probably in the other 3 different versions of the books, you have a very thick portion of it dedicated to rules of evidence.
Yeah.
My question is, how are these rules developed to ensure that the truth is seeked in a courtroom?
Well, the rules came about over many centuries and many decades, and they're in place to exactly do that, to promote, one of the slides that I missed or didn't really emphasize is the rules of evidence. The purpose of it is to promote truth and justice. So the courts that pass these rules, because in the end it's the court that decides what rules apply in its courtroom, in its courtrooms. The courts pick these rules because they think they are the most likely to allow the truth to come out and justice to be served. So that's what they're there for. That's the whole reason that they're there. Like hearsay. And here's why hearsay is bad, right? Because in the old days, and I skipped over this in the lecture, in the old days, they didn't allow it sometimes because you were supposed to take an oath if you were a witness, and a person who says something outside of the court didn't take the oath. But the modern reason to prevent hearsay is that you can't cross-examine. You guys know what cross-examination is? Who knows? Everybody knows what that is? When cross-examination is when the other side's lawyer, gets to examine my witnesses, or I get to examine the other side's lawyers. Cross-examination is the legal scholars think it's the best way to ferret out the truth, to determine what really happened. And in England, for example, because I've done a little bit of work in cases that have a connection with England. In England, in civil cases, you don't have direct testimony anymore. You don't have a witness getting up and saying, here's what I think happened. What happens in England in civil cases is you put in your direct testimony through a very long affidavit, and the trial in an English civil case is just a series of cross-examinations where the witnesses are called in, and the only thing that happens in court is cross-examination, which I think is really cool, and I think should happen in this country. It would make cases go quicker. But cross-examination, the reason why hearsay today is not allowed is because you can't cross-examine someone who's not in the courtroom. So in the example of Shanez telling me that Audrey shot JC, if she's somewhere else, she's not in the courtroom, and I get up and I say, hey, I heard Shanez tell me that Audrey shot JC, and Audrey's a defendant. Audrey's lawyer can't cross-examine her to see what she really saw. She can cross-examine me as the person repeating the hearsay, but not the person who's the original declarant. So that's why it's not allowed. It's cross-examination is not possible in hearsay situations. Yes?
What right does someone have to privacy when they're being sued with a civil case, and is there a different standard with a criminal case?
Right to privacy?
Like people examining your life, examining what you said.
Okay, so can you speak up?
Yeah.
Yeah, like, do you have a right to privacy when you're being sued for something that you've done, and people try to examine your life and see what you said before you?
Well, yeah, we have a right to privacy. There's a lot of law out there about the right to privacy. That's why the police can't come and just barge on your door unless they have probable cause to search your house. If I'm a police officer, I can't just pick your house because I feel like it and knock on the door and search it. I have to have probable cause. So you have the right to be private in your home. You have a right to be private in your emails. there's a whole body of law out there now dealing with right to privacy.
You as the main suspect, and all of how it happened. After that, at what point do you still have privacy after you're the main suspect? And what point?
But you never lose your privacy right. Are you talking about privacy before it happens or after it happens? After the trial?
During the trial process.
During the trial. Okay, that's another good question. Basically, once you're in court, once you're either in civil court or criminal court, nothing is private. Everything is public. So whatever you say in court, people can find out. Whatever happens in court, people can find out. So the defendant, doesn't have privacy with respect to what happens in court, and a criminal defendant doesn't. There are certain situations where you can seal things, like if it's national security or if it's a business trade secret. There's like all sorts of rules. But even in those, and we have those situations where I'm representing a company and we have a trade secret we don't want out there, and we say to the judge, "Hey, judge, we really don't want this out there." And the judge says, "Okay, well, that's your choice, because if we go to trial, I'm not keeping this secret. It's going to be out there." So then you have to decide. Are you willing to have that disclosed so you can enforce it, or would you rather not proceed in the case? So there's a whole really interesting stuff. And then there's the publicity rights. For example, here's another difference in state and federal court. Television, right? You saw the Trayvon Martin trial because it was in state court. And almost every state court, Florida definitely does, and probably every other state, allows court proceedings to be televised. When I was a prosecutor, and I might have given the greatest argument ever in the history of the world, but it wasn't on television, and it wasn't recorded, because you cannot televise a federal trial, whether it's a civil trial or a criminal trial. Same thing with the Supreme Court. Do you guys remember Bush v. Gore? Bush v. Gore. Okay. So I was involved, a little bit in the Bush v. Gore cases, and we had some cases that were argued in the Florida Supreme Court, and some cases that were argued in the U.S. Supreme Court. The Florida Supreme Court cases were televised, so you could watch the lawyers do their argument. In fact, if you want to watch a Florida Supreme Court argument, go to the Florida Supreme Court website, because FSU, the Florida State University, has a website that you can click on and look at people's arguments. My brother Frank, who JC also knows, once argued in the Florida Supreme Court, and I had fun because then I could watch him do his argument afterwards and laugh at the mistakes he made. But in Bush v. Gore, when it went to the U.S. Supreme Court, that wasn't televised, and instead what you see are pictures, those drawings of the lawyers arguing in court, because there's no television in federal court.
How do you determine probable cause? How do you prove it?
Probable cause? You just have probable cause is just a reason to believe something may be true or is true.
How do you prove it?
You just, if you're, I can give you an example from federal cases that I worked on. If I have an agent who says, "Hey, I saw this guy coming in and out of the house, and I have an informant who told me that there's drugs in the house, and I've done this other thing. I think there's drugs in the house." You just have it's very flexible. Basically, you have to convince the judge who is issuing the search warrant that probably there's something there, and that's very, very loose. And very few judges refuse to sign warrants. They almost always sign warrants because probable cause is a very flexible standard. Yeah.
When it comes to something that federally is not acceptable, but state-wise is, for example, like my cousin in California this week is actually getting married. He's gay. Things like that, gay marriage, marijuana.
Right.
How is it that sometimes, the federal court will come in and do something about it when it's state legal? Why does the federal court have the final say? Why doesn't the state law sometimes apply in that case?
Got it. Well, federal courts decide disputes between states. That's one thing. So if a state was involved in a dispute with the other state, I'm trying to remember how it is that the DOMA case and the other case from California came to the Supreme Court. But I think, I just don't, I don't remember right now, but I think it has to do with a federal constitutional right. So if something must have happened that involved a federal constitutional right that allowed then the Supreme Court to accept jurisdiction, because I remember I told you the federal courts are courts of limited jurisdiction. The U.S. Supreme Court is a court of the most limited jurisdiction. Less than 1% of the cases that the Supreme Court, the U.S. Supreme Court, is asked to take, it takes. So out of 1,000 cases that parties say, hey, would you take this case because they want to appeal it from an inferior court, either a state Supreme Court or a lower federal appellate court, they take, out of 1,000 cases, they take less than one. Like, I think it's like, maybe it's one. Actually, you know what? That may be an exaggeration. It could be like 2%, but it's very few. It's like 1, 2, or 3 out of 1,000 cases at the most. I looked that up the other day in a case. Yes.
Concerning the jury and like all the juries and things, you're basically like randomly selected without any criteria. It's just like, oh, you're a citizen, you have to serve, and then the jury. Wouldn't it be better if we had like some sort of like, now I don't want to say standard, but if you could like, because I feel a lot of times that some juries don't even know what they're doing, and that could really like compromise the whole case. Right?
Yeah.
Because they're the ones that pick which is like which evidence is valuable, right?
Right.
So like, wouldn't it be better if we had some sort of standard, I guess?
Yes,
for juries?
it would. Well, we don't have very many standards. You have to be 18. You have to be a citizen. You have to. You can't be a long time ago you couldn't be a convicted felon and then serve on a jury. Now they're restoring the civil rights to people because we're putting so many people in jail that now people are coming out. And but you know it's a good point because a lot of times you know, back in the old days juries were smarter, I think, and maybe paid more attention. Today they may not be as smart. I don't know. That could be. Can we erase that part of the tape? But
you have a process of where do you, I mean,
yeah,
you
but
have
that
a process.
right. But there is a process, and that's what I was going to get to, which is the lawyers have the right to ask questions, and lawyers can ask questions. Well, the judge in federal court, a lot of times it's only the judges who ask the question, and they give the parties very little leeway in terms of asking questions themselves. But in state court, you can go to town. You can ask. That's why sometimes you remember the Trayvon Martin case. It took weeks to pick the jury because even after they had screened all these people, the lawyers could ask questions and questions and questions. And what you're looking for is for depending on who you are, you're looking for someone who is a man or a woman or is smart or isn't smart or has a certain personality or doesn't have personality. And there are jury consultants. Lawyers hire experts to help them pick juries. There's some people that make a lot of money helping lawyers and their clients pick juries because they look at it scientifically and they determine what things are we looking for, what questions do we want to ask, and that kind of thing.
So the defendant's lawyer picks the jury.
No, both lawyers.
So the prosecution picks.
No, both. Both. What happens? Yeah. Do you want to hear about how you pick a jury? Okay. Here's how you pick a jury. So, a bunch of people come into the courtroom that meet that 18. You're not a felon and all that stuff. You're a citizen. And then the judge asks a few preliminary questions, and then or a lot of questions, and then sometimes the attorneys get to ask questions. Sometimes they don't. Usually they do. And then each side. So in a criminal case, the prosecution and the defendant have a certain number of challenges. They can strike a certain number of people from the jury. So I don't remember the exact numbers, but when I was a prosecutor, I think I had say 6 strikes, and then the defendants had more. They always gave the defendants more under the federal system. So let's say I had 6 and they had 9. So then you can use that strike on anybody you want, except for certain reasons. Like you can't strike somebody just because of their race. That's a whole constitutional area of the law that developed. So, unfortunately, there were prosecutors in certain places and in old days who would strike if the defendant, for example, was African American, who would strike all the African Americans in the jury. And that was not fair, so they made the Supreme Court decided that was unconstitutional. But then there's also strikes that are for cause, which means that the judge gets to make them. So the judge said, so if somebody says, hey, I don't think I can be fair because my dad is an FBI agent, the defendant would get up and say, strike that juror for cause, and the judge would probably agree, strike that juror is gone. But that doesn't count against the number of strikes that the defendant, because you have 6 or 9 or whatever, or 12, no matter what, you can use for any reason other than racial reasons and other reasons, a few other reasons. You guys are like testing my memory on a lot of things. Yes?
There was an article that I read someplace that basically described the role of the jury. I read an article someplace that describes the role of the jury as not only the judge of the evidence, but judge of the actual law. So I guess my question is, can juries ignore the law?
Can they ignore the law? That's a really good question. The answer is yes, but there are ways that a party, a person, the plaintiff or the defendant or the prosecutor or the defense attorney can get around it. You can ask the judge to overturn the jury's verdict because it's against the law, and that happens sometimes. And sometimes cases don't even get to the jury because the law favors one side so much that it doesn't get to the jury in the first place. So before a case gets to, and by the way, jury trials are very rare. When I was a young prosecutor, there were a lot more cases that went to trial. Today, the trial system is vanishing because we have so many cases. It's so expensive to try cases that every year, if you look at the statistics, less and fewer cases are tried in court in jury trials. So a lot of times you can waive a jury trial. Parties can agree not to have a jury, and that happens a lot. In commercial disputes, both sides will say, okay, we don't want a jury trial, let's just go to trial and have the judge decide everything. Have the judge decide not just the law, but also the facts. Now there's who knows what arbitration is? Arbitration, parties can agree to arbitrate a dispute, which means it's a private resolution. Instead of going to court, you go to an arbitration system where there's private people that decide who wins and who loses, not criminal cases, but in civil cases, you have arbitration. So there's all sorts of things. There's mediation where people get together before trial and try to settle, and there's mediators, the guys that have a lot of business, and all they do is mediate. And they try to get parties to settle before they go to trial in civil cases. There's no mediation in criminal cases. There's ways to prevent the jury from ignoring the law. Yes?
I have 2 questions. My first one was, why do some lawyers do
Pull the jury? Uh-huh.
And the other one is there a difference between a grand jury and a normal jury?
Yes. The reason why some people pull the jury is that it doesn't happen very often, but sometimes if there's a juror who is not sure, and it's happened before, each juror has to say, yes, that's my verdict, yes. Sometimes you get to the 5th person and that guy says, well, I'm not really so sure, and then boom, that creates a big problem, which is good if you're in a criminal case. That's good for the defendant if that person's about to be found guilty. Your second question was grand jury versus the trial jury. Grand jury is just a group of citizens that are there to decide whether or not the charge should be brought in the first place. So they only hear evidence from the prosecutor. They don't hear evidence from anybody else. So it's very controlled. It's only the prosecutor with the grand jurors, and there's evidence. And there are lots of rules that deal with grand juries, but in the federal system, you have to have a grand jury indictment for every felony case. Everything that's a felony unless you waive, sometimes if you're a defendant, you can waive indictment by a grand jury. If you want to plead guilty from the very minute the case is brought against you, you can waive that process. You can plead guilty without a grand jury. But it's a little bit of an anachronism, but I think it's still a good check on prosecutors because they have to present things to people who actually have to agree, yeah, we think there's probable cause to bring that charge. Yes?
Okay, so in Gilbert's treatise and in the books that you have, they outline things that qualify as evidence. So if you have two lawyers, they're like, okay, there's a house deed, like they both agree that's a legal document that works with it. So what happens when you go into the international sphere and other places have different rules for what qualifies as evidence? Does the United States ever have to convince someone else that like this is real evidence and like this is why it's evidence? You know, does that ever happen?
Not really, because every country has its own rules of procedure, its own court system, its own rules of evidence, and there really aren't situations where the U.S. is itself involved in a dispute where there's any question about the rules of evidence. There are international arbitration bodies and there are other treaty bodies that handle disputes between countries, and those have their own set of rules and both countries sign up for it, so everybody knows what the rules are. So that doesn't really happen. But yeah, there's lots of people that think that our evidence rules aren't good, and we think that everybody else's evidence rules aren't good. But I don't know that much about. I know some, but not a lot about other countries. But I know I asked you this before, but I think the jury trial system in this country is great, and I think it works really well. And it's, I think, the best system that's ever been developed, the most fair system that's ever been developed, to protect people from the government, and then also to let the government fairly prosecute people. And I think that about jury trials in criminal cases. Do I think the same thing about juries in civil cases? No. I think that juries aren't as important in civil cases. Unless you're a personal injury lawyer and you want to convince the jury to give your client $1 billion, but even that's changing because the laws are changing, and they're putting caps on what you can recover for medical malpractice. They're putting caps on what lawyers can earn. They're putting caps on punitive damages. So the society ends up reining that in anyway. So I don't think jury trials are as important as in the civil arena as they are in criminal. Yes.
Well, we're one more question. We're actually out of time, but one more question because Patricia really needs it. But you want to ask Mr. Jimenez afterwards? Well, join me in thanking.